A happy July 4th to all of you, and hopefully you are all enjoying your holiday weekend off. Of course, here at Brother Counsel Studios, we are still working hard every single day to bring you the content that you have come to expect and enjoy. Now, before we jump into today's topic, I want to let everybody know that this Sunday, July 6th at 9:30 in the morning, I will be joined by none other than National Trial Attorney Solomon Radner, Brother Counsel's Brother Counsel, also known as Brother Solomon, to discuss everything that happened last week as it relates to Karen Reed and anything that can possibly be affected in the future. So join us right back here July 6th, this Sunday at 9:30 a.m. for that discussion. Now, Karen Reed has been sued in civil court. So we already know about the criminal case. She was acquitted, but she was found guilty of OUI, plain OUI, operating while under the influence of alcohol. Well, now she is also being sued in the civil courts for wrongful death. Now, there's another part of that case, and that is the O'Keefe family is suing the bars, the Waterfall and C.F. McCarthy's. So there's two separate causes of action. One is against Karen Reed, and of course, they all center around one very important question, and that is whether Karen Reed's Lexus had any sort of interaction with John O'Keefe. We saw what happened in the criminal case, and now the question is going to be in the civil case. The difference is obviously the burden of proof is very different in a civil case. In the criminal case, you have to prove beyond a reasonable doubt, which is the highest burden known to mankind. And in the civil case, you just have to prove your case that it's more likely than not. Now, I've told you that if you give me the ARCA experts, I would be very confident to represent Karen Reed and feel very confident in her chances of getting a no cause, meaning that she would not be held liable for anything as long as she has the ARCA experts testifying on her behalf. We saw that there's really been no real reconstruction that was done on from anybody else to show that there was an accident. We can't call what Dr. Welcher did a accident reconstruction, but who knows? Maybe in the civil case, the O'Keefe family's civil attorneys will actually hire people to do a real reconstruction and perhaps show how this is all possible. But until that happens, I would still be very confident in Karen Reed winning the civil lawsuit. Now, that's really as it relates to the wrongful death. But there's also another very important part of this, and that is the dram shop, which is against the bars, C.F. McCarthy's and the Waterfall. And the way that works is that even though they didn't drive the car, obviously, but since the allegation is that they served Karen Reed alcohol while she was visibly intoxicated, then they can be held liable for the damages that she caused. So again, the first step is obviously they're going to have to prove that there was an accident. But the second step is in the dram shop, is to show that the bars served a visibly intoxicated person. So I've been speaking broadly about that cause of action and whether it has any merit. And today, what we're going to do is go through some of the seminal cases in Massachusetts that discuss this very topic about the dram shop. So let's start with one of the most important cases, and that is Vikowski. Vikowski is cited many, many times throughout different opinions in Massachusetts when it's talking about dram shop. So let's see what happened in Vikowski. It's a case that was decided in 1996, as you can see. And let's see what happened here. So here we have the following. As of 1992, Finden Kevez had been visiting the club, the defendant in this case, an establishment licensed to sell alcoholic beverages for about 13 years, on an average of 4 to 5 times a week. So he was a frequent visitor of this club, Finden Kevez, 4 to 5 times a week for about 13 years. Finden Kevez generally went to the club to drink beer. On Saturday, November 28th, 1992, between 2:30 p.m. and 4:20 p.m., so that's about 2 hours, he consumed 4 or 5 12-ounce bottles of beer while at the club. He had consumed no alcohol prior to his arrival there. While drinking, he sat alone and quiet on a stool at the bar watching television. He had nothing to eat. And obviously, when you eat, that also affects the alcohol. Continuing. Finden Kevez's son, Stefan Finden Kevez, was the bartender at the club that afternoon. Stefan, whose training in the bartending was limited to a couple of weeks of an on-the-job training, was accustomed to serving beer to his father at the club. So you got his son, who's actually serving him bar. He probably got him the job, but now his son is serving him bar at this bar that he goes to. Stefan indicated in deposition testimony that when his father arrived at 2:30 p.m., he was not obviously intoxicated. That when his father ordered beer in the course of the afternoon, there was no indications which led Stefan to believe that his father was intoxicated, and that he did not believe at any time that day that his father was intoxicated. So here you got Stefan saying, look, he didn't look intoxicated, never looked intoxicated to me at all. Stefan made no effort to monitor his father's condition on the afternoon in question. He did not have any conversation with his father, and he did not see him get off his stool and walk at any time. Stefan did not refuse to serve his father and indicated that he would not be concerned about a person's ability to operate a motor vehicle after the consumption of 4 to 5 beers. Finding Kevis indicated, now we're talking about the father, Finding Kevis indicated that 4 to 5 beers was an unusually large amount for him to drink during the length of time he was at the club that afternoon. So normally he had less, but this time he had 4 to 5. There was no other evidence concerning Fighting Kevis' condition or appearance during the relevant 2-hour period. Neither Fighting Kevis nor Stefan was able to recall the name of any other person present in the club on the day of the accident. So there's no witnesses, there's no testimony. The only witness is Stefan, his son, who said he didn't look intoxicated at all. And other than that, all you have is that he drank 4 to 5 beers. But it doesn't end here. Finding Kevis was served his last beer around 4 p.m. He left the club sometime before 4:30 p.m. and apparently stopped briefly at a local grocery store. Shortly after 4:30 p.m., his automobile struck and severely injured the plaintiff as she was crossing a street. A Deerfield police officer who was called to the scene of the accident observed that Fighting Kevis smelled of alcoholic beverages, that his gait was unsteady, and he swayed when he was standing still, that his movements were slow and deliberate, and that his eyes appeared bloodshot. So all of the indications of an intoxicated person, very visibly intoxicated, and this is only a half hour after he was at the bar when he drank his last drink, or maybe 45 minutes at that point. About 1/2 hour later, Finding Kevis failed field sobriety tests administered by the officer, who observed at this point that Finding Kevis' speech was somewhat slurred. So at this point, all the indications, his speech is slurred, he can't stand straight, his gait is unsteady, he stinks like alcohol. I mean, this is only a half hour to 45 minutes after he was served his last drink. The officer arrested Finding Kevis for operating a motor vehicle while under the influence of intoxicating liquor. Finding Kevis was later convicted on that charge. 2 witnesses to the accident also furnished information about Finding Kevis' demeanor at the scene. One of these witnesses indicated that she smelled alcohol on Finding Kevis and that he was stumbling all over his own feet. The other witness also smelled alcohol, observed the stumbling, and described Finding Kevis' speech as babbling. Both witnesses opined that Finding Kevis was obviously intoxicated. So it is very clear from this case that, and again, this is the Vikowski case, that this defendant, Fighting Kevis, and again, he's not the real defendant of that matters here. It's the bars that served Fighting Kevis. But by all accounts, at least a half hour to 45 minutes after he was at the bar, he was completely drunk, obviously intoxicated. So was that going to be enough? That's the question. Is that going to be enough to say, well, probably 45 minutes before then, he was also obviously intoxicated when he was served that last drink. And if a bar serves an obviously intoxicated person, well, then that bar is going to be responsible for the damage that Finding Kevis caused, or in this case, personal injury, right? Okay. So the plaintiff, in support of her claim, the plaintiff does not rely on direct evidence of Finding Kevis' conduct or demeanor at the club, right? We don't have any direct evidence what his demeanor was at the club. Lacking such evidence, she contends that a jury properly could infer from the evidence of Finding Kevis' demeanor and behavior furnished by 3 witnesses at the scene of the accident that he must have been showing similar apparent signs of intoxication a half hour and 1 beer earlier. Therefore, she reasons a jury could conclude that the club violated its duty to the plaintiff and failed to exercise the degree of care for the safety of pedestrians that ought to be exercised by a tavern keeper of ordinary prudence in the same or similar circumstances. So, yeah, come on. There's got to be at least a half hour that he was visibly intoxicated, and therefore the bar should have never served him. We think, listen to what the court says, we think this particular leap, unsupported, by additional probative evidence, direct or circumstantial, bearing on Fenninkevich's conduct or demeanor at the club would not permit a reasonable inference to a sufficient degree of probability and would, in effect, impose liability on the basis of unaccepted speculation on the part of a jury. As has been previously noted, a tavern keeper does not owe a duty to refuse to serve liquor to intoxicate a patron unless the tavern keeper knows or reasonably should have known that the patron is intoxicated. The negligence lies, listen to this, the negligence lies in serving alcohol to a person who already is showing discernible signs of intoxication. A plaintiff's evidence must be sufficient to establish that more probably than not, the patron in question was exhibiting signs of intoxication before he or she was served a last alcoholic drink. So it all, again, centers around the idea that the bar will have liability if there's evidence sufficient enough to establish that the person was exhibiting signs of intoxication. And this is a case that is very obviously very helpful for the bars in Karen Reed's case, because by all of the evidence, all of the testimony, all of the surveillance footage, she did not appear visibly intoxicated at all. She wasn't slurring her words. And in fact, remember, the last person to speak to her that night, other than John O'Keefe, was Karina Kolakithis, who said that she had an hour conversation and she was sharp on the ball, wasn't slurring her words. Everything was completely fine from her vantage point, and she was not intoxicated. Just a few more quotations here to other cases from the Vikowski case. It says like this: patron, citing Semino, that a patron was totally drunk, loud, and vulgar. That was that in the Semino case. We're going to see more about the Semino case a little bit later. And again, commercial establishment could not be liable when there was no evidence of obvious intoxication while patron was at the bar. Finally, in other words, a jury confronted with evidence of a patron's excessive consumption of alcohol properly could infer on the basis of common sense and experience that the patron would have displayed obvious outward signs of intoxication while continuing to receive service from the licensee. Okay, we're going to see more about this in a moment. But from very obviously from the Vikowski case, it would seem that the bar, in this case, C.F. McCarthy's and the Waterfall, has absolutely no liability for anything. Meaning, even if you're able to get over the hump that Karen Reed did back up her car into John O'Keefe, which again is not a simple task at all. But even if you're able to get past that, the question is, are the bars going to be liable for that case? And here, it doesn't seem that way at all from the Vikowski case, because by all accounts, she was not visibly intoxicated at all. But the cases do go on, and maybe there'll be an argument that maybe they could have some level of liability. Why is that? Well, let's move on a little bit more, and we'll see another case that deals with alcohol consumption and whether a bar can be held liable. So here we have the case of Douliard versus LMR. And in this case, the following happened. The defendant, LMR Inc., operated a tavern known as Breakers Billiards and Brewers. On the evening of March 25th, 1994, Stephen Gagne was a patron at the defendant's establishment, arriving at approximately 8 p.m. and remaining there until sometime after midnight. So he was there for about 4 hours. Okay, Stephen Gagne was there for 4 hours. Gagne had not consumed any alcohol beverages that evening prior to his arrival at the defendant's tavern. He had eaten 3 meals that day, so he ate a lot. Gagne claimed that during the roughly 4 hours he was at the bar, he drank 4 drinks of rum and Coke, that he was served a 5th drink, and that he had consumed a portion of that 5th drink before his departure. So he only had 4 drinks and a little bit of a 5th drink. Now, Gagne himself is 5'2" and 1/2 inches. And at the time of these events, weighed between 130 and 140 pounds. So not the biggest guy in the world. He's only about 5'2.5", and he weighs 130, 140. And he had about, 4 drinks and a little bit of the 5th drink. That was his testimony, and it was over 4 hours. At around 1 a.m. on March 26, 1994, Gagne's vehicle crossed into the oncoming lane and struck a vehicle operated by the plaintiff, Robert Douliard. So Robert Douliard is a plaintiff in this case. Both Douliard and Gagne were seriously injured in the collision. When examined at a hospital, a blood sample drawn from Gagne revealed that he had a blood alcohol concentration of 0.149. Now, if you remember in the Karen Reed case, her blood alcohol was also pulled. Now, of course, her blood alcohol was pulled at the hospital at 9 a.m. and they had to do this whole retrograde to back it up into what would have been at 12:45. But according to Hannah Knowles, her blood alcohol level was about 0.14 to 0.28, somewhere between that range. So very similar to this case, Gagne, where you have this expert pulled his blood and said that it was at 0.149 at 1:56 a.m. For his role in the incident, Gagne was charged and convicted for operating while under the influence, resulting in serious bodily injury and operating negligently so as to endanger. So, okay, he was convicted of that in the criminal case. 4 of Gagne's friends and acquaintances testified in Gagne's offense at his criminal trial. So you have his 4 friends testifying on his behalf. They had seen Gagne at the bar that night and testified that in all respects, up through the time of his departure, he had shown no signs of intoxication whatsoever. Okay, again, sounding very similar to the Karen Reed case, right? All the friends testified, everyone in there testified that Gagne, in this case, in this opinion, showed no signs of intoxication. At deposition, now listen to this carefully. At deposition, one of those same friends testified that he had, on approximately 10 prior occasions, seen Gagne when he was intoxicated. So one of the friends said, look, I know what he looks like when he is intoxicated, and boy, he was not intoxicated that night. And I've seen him intoxicated before on 10 other occasions. Now, the friend described that when intoxicated, Gagne became overly social, loud, sick, and giddy. The witness further specified that by the term overly social, he meant hugging people, laughing, and loud behavior, that by the term sick, he meant vomiting, and that by the term giddy, he meant laughing and laughing inappropriately. At his deposition, Gagne testified that he had on prior occasions become intoxicated after drinking 7 rum and cokes, and that in his experience, it took 7 such drinks to render him intoxicated. So let's stop for a moment and let's think about this. Okay, so at the night in question, everybody testified he was fine. He did not have any sort of signs of intoxication, and Gagne testified that he only had 4 drinks, maybe a little bit of a 5th drink. Now, in Gagne's own deposition, which is also, Karen Reed's going to be giving a deposition in the civil case, in his deposition, Gagne testified that on prior occasions, it took him 7 drinks. Right, this time I only had 4 drinks and maybe a little bit of a 5th drink. On other occasions, I'm telling you, it takes me 7 drinks to get intoxicated or to even feel intoxicated. And then you have that with the other witness who testified that when he does get intoxicated, he is overly social, he is loud, sick, and giddy. But not that like anything that happened in this case. Now let's continue. In opposition to the summary judgment motion. So now you have what happened in this case is that the defense filed a motion to dismiss the case, which is going to happen in the Karen Reed case also. And I think that they should probably be successful in the Karen Reed case. But let's just see what happened in this case. In the Gagne case, this is the case is called Douliard, but Gagne was the one who was driving the car intoxicated. So they filed a motion to dismiss the bars. They said we should get dismissed on this case because there's no evidence that Gagne was visibly intoxicated, and therefore the bars are not liable at all. So what did the plaintiff do in response? Well, in opposition to the summary judgment motion, the plaintiff submitted an affidavit from an expert witness. And this would be an expert witness very similar to Hannah Knowles in the Karen Reed case, setting forth a calculation of Gagne's blood alcohol level at the time he was served his last drink. Based on the time frames testified to by Gagne, his height and weight, his consumption of food that day, and his blood alcohol level as determined by the hospital at 1:56 p.m., the expert opined that Gagne's blood alcohol level would have been 0.154% at the time he was served his last drink. Okay, so the expert says, and this is exactly what happened in Karen Reed's case, very similar, that after doing all of the analysis, his blood alcohol level would have been 0.154. Now remember, Karen Reed was supposed to be somewhere between 0.14 and 0.28. And then he basically opined that most people are not going to read this entire next part, but this expert in this case opined that most people, when they are at that level of 0.154, would exhibit outwardly indications that they are intoxicated. The expert also opined that to reach the blood alcohol level shown at the hospital at 1:56 a.m., it seems like they mix up PM and AM here, Gagne would have had to consume at least 9 drinks that evening, not the 4.5 drinks that Gagne acknowledged. So now the expert's saying, someone may not be being completely honest with you, because according to the data, according to the science in this case, he must have drunk at least 9 drinks, not the 4 or 4.5 that he claims that he drank. So now this is getting a little bit more interesting. Is that enough evidence to get in front of the jury to be able to argue your case? Meaning the motion to dismiss is that we shouldn't even go to a jury, and the plaintiff is saying, no, we get to go to a jury because there's enough evidence here that a jury can reasonably conclude that this guy Gagne, was actually visibly intoxicated at the bar when he was served his last drink. So what did the court find? The court found the following. Evidence of apparent intoxication or of elevated blood alcohol levels at some later point in time does not by itself suffice to show that the patron's intoxication was evident at the time the last drink was served. So you cannot just use a Hannah Knowles, someone like that, or some expert to say, hey, look, we did all the calibration and the retrograde analysis. We did everything, and it shows that this person was very intoxicated, and therefore it must be that he was visibly or she was visibly intoxicated. You cannot just rely on that. That's what this says straight out. Again, evidence of apparent intoxication or of elevated blood alcohol levels at some later point in time does not by itself suffice to show that the patron's intoxication was evident at the time the last drink was served. Continuing down, the use of such expert testimony relating blood alcohol level to the appearance of signs of intoxication has been rejected by some courts on the ground that it fails to take into account the wide individual variability in alcohol tolerance. We all understand this concept. Some people can handle the alcohol very well, and they won't come across as drunk, even though they really are deep down inside and in their blood. But they can hold it very well. It is common knowledge that some people are in common parlance better able to hold their liquor than others. Thus, it is argued expert opinion concerning what signs of intoxication are displayed by the average person or by most people at particular blood alcohol levels should not suffice to prove whether a particular individual actually displayed such signs at those levels. So just having an expert saying, yeah, most people would exhibit some signs of intoxication at these levels should not be enough. Now, listen to what the court says about that. Assuming without deciding. So basically they're saying we are not going to decide on that issue today. We're not going to decide whether we are completely embracing that or not. But even if we were to assume that the problem of individual variability in response to alcohol prevents a plaintiff from relying exclusively on an expert opinion to make out a case of apparent intoxication, the present case does not rely solely on the expert opinion about what signs of intoxication a normal, average, or typical drinker would exhibit at a blood alcohol level of 0.14%. That's not what this case is completely relying on. This record adds to the expert opinion specific information concerning this particular drinker's reaction to alcohol consumption. So in this case, it's not just that the plaintiff has this expert that is saying that if you do this retrograde analysis, this was the level that he was at, and most people would have show signs of intoxication. No, that's not exactly it. That's not the limitation of what the plaintiff is presenting. Gagne himself acknowledged that he would, after consuming 7 drinks, become intoxicated. Remember, that was his deposition testimony, where the expert calculated that Gagne's consumption on the night in question had to be at least 9 drinks. So again, according to the expert said, look, according to the science, he had 9 drinks. And according to his own testimony, he would have been intoxicated at 7 drinks. And on top of that, remember the other witness who testified, there's evidence that the amount consumed by Gagne put him at least 2 drinks beyond the level of alcohol consumption at which he would customarily become intoxicated. As to whether Gagne, when intoxicated, was a person whose intoxication would manifest outward signs, a friend who had seen him intoxicated on 10 occasions confirmed that Gagne would indeed exhibit such signs. So remember that other witness, his friend, testified, oh yeah, I've seen him drunk before. He was doing it to help his case in the criminal case, but now it's coming back to hurt him in the civil case because he's saying, look, I've seen him drunk before, and this was not him drunk. But when he is drunk, this is the signs that he exhibits. So according to Gagne's friend, excessive alcohol consumption would make Gagne overly social, loud, sick, and giddy, as we explained in this opinion before. When intoxicated, Gagne would hug people, engage in loud behavior, vomit, and laugh inappropriately. In other words, where the expert opinion was that one would expect to see signs of intoxication at the blood alcohol level that Gagne reached after his estimated 9 drinks, the testimony of Gagne and his friend confirmed that Gagne would customarily become intoxicated and exhibit several signs of intoxication after consuming only 7 drinks. So what this court found is that the plaintiff's case could go forward. We're not going to dismiss the bars outright. Now, I don't know what happened ultimately in this case, whether the case settled or not, or whether it was tried, but at least to get over the motion to dismiss, the court found enough evidence coupled with the expert's testimony in order to support the reasonable conclusion that it's possible that he did show signs of intoxication. Now, let's try to apply that to the Karen Reed case. Is there anything other? Is there anything other than the expert's testimony in her case of what her blood alcohol level was? And again, the answer is no. There's been no corroborating evidence. There is no one who testified yet. And again, maybe they'll take more depositions in the civil case, but we have not heard any sort of evidence that what Karen Reed is like when she has, 4 or 5 vodka tonics or whatever it is. And, there's no corroborating evidence at all. And the only evidence is to the contrary, that she was not exhibiting any sort of outward signs of intoxication. So again, this is another case that helps the bars as it relates to Karen Reed's civil case. But let's pull up one more case, okay? Because you always got to go one more case, right? This is the case of Rivera versus Club Caravan. And this is a 2010 case. We started with 1990. Was it 1992, I think it was, Vikowski, or 1996, and this was a little bit later. Now we have 2010. Now let's take a look at this case for a moment. This is going to be like the second to last case that we look at, but it's very quick. So again, here's the case, what happened here. Sometime around midnight on January 27, 2001, John Bright arrived at the Club Caravan bar in Rivera to drink with friends. While there, he was served 14 drinks, most of which he finished. Bright felt intoxicated while at the bar and was stumbling by the time he left around 2 a.m. After stopping to get some food at a local restaurant, Bright drove south and he crashed into Trooper Shea's cruiser at approximately 3:30 a.m. Bright pleaded guilty to driving under the influence, for which he served jail time. Okay. So that was the quick summary of what happened in this case, Rivera. Although, this is what the court found in this case. Although there was no direct evidence that Bright was exhibiting outward signs of intoxication before he was served his last drink, and some testimony to the contrary, the plaintiff's proof did not fail as a matter of law. Where the jury could have concluded that Bright was served 14 drinks over a 2-hour period and drank most of them, it was for the jury to decide whether Bright likely appeared intoxicated before he was served his last drink. So, what is the court saying here? The court is saying here in Bright's case, since he was served so much alcohol, 14 drinks, and he drank most of them in a 2-hour period, well, then that is enough to get to the jury, even without anything more corroborating evidence. Now, I will say to you that he did say there was actually some corroboration here, and I don't know why this court decided to ignore it, but there is some corroborating evidence in the fact that he was stumbling by the time he left. Well, that's outwards showing visible intoxication. But this is really the first case where you're going to have a court that's going to say that just by the fact of how much this person was served, how much he drank, there is going to be enough. That's enough evidence that a jury can conclude that he must have been visibly intoxicated. Right now, I think it could have been very easy for this court in this opinion, to say that there was more. Right, there was also some visible intoxication, the fact that he was stumbling. Okay, but then look what the court says here. It was for the jury to decide, right? And then they say compare Semino. Remember, we saw that case earlier. Semino versus Milford, service of 6 or more White Russians, and Vikowski. Now, Vikowski, we said there was only 4 or 5 bottles of beer, and it was only sipped over approximately 2 hours, whereas the Semino case was 6 or more White Russians. Now, White Russians are much stronger than a beer. But if you take a look at Semino, it's actually not so clear about that, but I can see where they're coming from. So in Semino versus Milford, because you would think that you need some more corroborating evidence, not just enough by how much they were served. But this is what happened in Semino. Mott went to the Milford keg on January 19th, 1976, and was served 6 or more White Russians between 1 p.m. and 6 p.m. While there, Mott played pool and became drunk, loud and vulgar. might have been ejected from the Milford keg in earlier occasions in July or August 1975 for loud, boisterous, and drunken behavior. On the date of the fatal accident, he did not remember at what time he had his last drink there, when he left, or how he got to his next destination. So this is a guy who's clearly drunk. He doesn't remember where he was, and he was loud and vulgar. And what the court found here, look what it says here. Now, again, you have other indicia of his drunken state, of his visible intoxication. But the court said the following. The plaintiff, however, introduced sufficient evidence from which the jury could infer that Mott was visibly intoxicated when he was served. Mott's loud and vulgar conduct and the defendant's service to Mott of a large number of strong alcoholic drinks was each sufficient to put the defendant on notice that it was serving a man who could potentially endanger others. There was no error on this ground. So this is really where you start to see the type of argument where it's enough, even if there's no testimony at all of how this person was acting, where you can make the argument, if you're a plaintiff, that just by serving such a large amount of alcohol is enough for the jury to assume that this person was visibly intoxicated, even if no one, you don't have any sort of corroborating evidence. However, I would definitely still argue that if you have evidence to the contrary, where you have clear evidence that the person was not visibly intoxicated, then that would still defeat even this. But even if you want to get in the door through this, again, you're going to have to make the argument that this is similar, that what Karen Reed was served at C.F. McCarthy's or the Waterfall, and definitely the Waterfall, I mean, they had no idea what she drank before. So the Waterfall should be completely out very easily. But even C.F. McCarthy's, where she was served a number of drinks, is that the same as being served? What was this? How many drinks was he served? These 6 or 7 White Russians. And in this case of Rivera, he was served 14 drinks. Is that the same as what Karen Reed was served? And again, on top of that, you have all of the evidence to the contrary. So this is why, again, I still think very strongly that the dram shop action, even if you'd be able to get beyond the fact that there was no collision here, as Alan Jackson said a number of times, and which the jury found in the criminal case. So still you have to overcome that there was actually collision in this case. But even beyond that, in terms of the dram shop action, it's going to be very, very difficult. And I think that there's a very strong case for the bars to be able to get out of this civil litigation. So that's going to be it for today. Again, hopefully everybody has a wonderful weekend. Join us right back here Sunday, 9:30 in the morning for my conversation with Brother Counsel, Solomon Radner. Have a great weekend. We will see you all on Sunday.